right, everyone, welcome back to the Deep Dive. Today, we're going to be taking a look at something really fascinating,
Yeah.
and that is artificial intelligence,
Mm.
AI,
Mm.
and how it's really sort of starting to impact the worlds of art and writing.
Yeah.
Um, we've all seen some pretty incredible things, with like Amelia's film,
Yeah.
where they were using AI to generate just these incredible visuals. And that's just the tip of the iceberg, really.
It is.
Experts are predicting that by 2026,
Wow.
AI is going to be a major part
Yeah.
of how video games, movies, TV shows, all that stuff is produced.
Yeah. It's exciting and a little bit scary too, right?
Yeah, I mean, and that's a good point because, along with all this excitement,
Yeah.
there is also a lot of, well, what our source called FUD,
Yeah.
fear, uncertainty, and doubt,
Right.
especially for artists and authors.
Yeah.
There are some really big questions about who owns the stuff that AI creates.
Mm.
You know,
Right.
can you even copyright it?
Yeah.
And is it even fair the way these AI programs are learning from,
Yeah.
basically looking at millions and millions of pieces of art and writing that already exist
Absolutely.
and, kind of sucking up all that data.
Yeah. A lot of open questions, a lot of uncertainty.
Exactly. And that's what we're going to try to unpack today in this deep dive.
Okay. Sounds good.
We really want to give you the legal lay of the land when it comes to AI.
Right.
And for us today, we're going to be focusing on copyright.
Mm.
That's the law that basically protects
Right.
creators' rights to their work and how all of this new technology is kind of shaking things up.
Right.
Now, we won't get into performers' rights today. That's a whole other can of worms.
Yeah.
But just know that, that's another important part of this conversation.
Another time.
Yeah, absolutely. So to give you a bit of a roadmap for where we're going today, we're going to be looking at three main things.
Okay.
First, we're going to talk about the court cases.
Mm-hmm.
There's some really big lawsuits happening right now about whether you can even copyright something made by AI
Mm-hmm.
and whether it's okay for these AI models to learn by looking at, existing art and writing that's already copyrighted.
All very messy right now.
It is very messy. And then we'll take a look at what the government is doing about all of this.
Okay.
What are they thinking? How are they responding to this, crazy new world?
Yeah. Are they stepping in?
Yeah. And finally, we'll look at how groups like, labor unions,
Okay.
which represent a lot of creators, artists, writers, actors, and so on,
Yeah.
how they're trying to protect their members in this new AI age.
Very interesting. Yeah.
So let's start with that first big question.
Yeah.
Can you actually copyright something that was made by artificial intelligence?
Okay.
And there's this fascinating case called the Thaler case
Oh.
to kick things off.
Okay.
So picture this guy named Stephen Thaler created an image using an AI program he invented.
Okay.
And he said that the AI pretty much did it all on its own. He just kind of set it up. So he decided to try to copyright this image,
Yeah.
but not in his own name.
Oh, interesting.
He wanted to copyright it in the name of his AI model,
Interesting.
which he called Davos.
Davos.
Yeah.
Okay.
So he goes to the U.S. Copyright Office, and you know what they say?
What'd they say?
No way.
Really?
Yeah, they basically said, look, to get a copyright, something needs to have a human author.
You're right.
And in this case, they didn't see enough evidence that a human being was really behind the creation of this image.
Interesting.
The way that copyright law normally works.
Right.
But of course, that wasn't the end of the story.
Right.
So Thaler takes this to court, to the federal district court in Washington, D.C.
Okay.
And guess what?
What?
The judge agreed with the Copyright Office.
Wow.
Yeah, he basically said, for years and years, copyright law has assumed that, it's about stuff created by human beings.
Right.
And this whole idea of an AI being the sole creator just didn't fit that traditional understanding of copyright.
Right. Well, copyright law has always been about human creativity, right? About people expressing themselves through their work.
Exactly.
So this idea of an AI being the only creator, yeah, it really throws a wrench in the system.
It does. And this case, it's still going on.
Oh, wow.
It's actually under appeal now,
Okay.
which means it's gone to a higher court called the D.C. Circuit Court of Appeals.
Okay.
They're going to be hearing arguments later this year,
Oh, wow.
and we might have a decision by June 2025.
Okay. So we'll have to keep an eye on that one.
Definitely. So it's a really important case because it could really change how we think about AI and copyright.
Right.
The question is, really, does copyright always need a human author?
Yeah, that's a big one.
It's a huge question.
It is.
And think about the implications of that. If AI can create things that can be copyrighted without a human really doing much,
Right.
what does that mean for the demand for human artists and writers.
Yeah. Do we even need artists anymore? I mean, scary thought, but
I mean, it is kind of a scary thought. And, it does make you think.
yeah.
But, it's important to remember when we talked about, like, Amelia's film, for example,
Yeah.
the AI was being used as a tool by human filmmakers.
Right.
So the humans were still really in control.
Right. They were making the creative decisions.
Exactly. And the Copyright Office has actually made it pretty clear
Mm-hmm.
that when an AI is just taking a prompt from a person
Yeah.
and spitting out some, complex work,
Yeah.
that the real authorship and those traditional parts of being an author, the creative choices, actually executing
Yeah.
artwork that's mostly happening within the AI itself.
Mm-hmm.
The human might give it the initial idea, but they don't really have that same level of direct control.
Right. Like an artist with a paintbrush or writer with a pen.
Exactly. It's a different kind of thing.
Yeah.
It's almost like the Copyright Office is thinking about traditional art in terms of predictability.
Predictability.
Yeah.
Yeah.
Like if you have a painter who uses certain techniques,
Yeah.
you can kind of expect a certain kind of outcome.
Right. You can sort of anticipate what they're going to paint.
Yeah, and they assume there's this clear connection between the artist's intention
Yeah.
and what they actually create.
Right. They have that vision in their mind.
Yeah, and the Copyright Office calls this idea determinacy.
Determinacy.
Yeah, it's like if you're baking a cake from a recipe,
Mm.
you follow the steps,
Right.
and you generally know what the cake's going to look like at the end.
Yeah. You know what to expect.
Right. And they see traditional art creation as kind of similar.
Okay.
But with AI, it's different because the process feels a lot more unpredictable.
Right. You never know what you're going to get.
Exactly. Sometimes even surprising.
Yeah. Yeah.
And they argue that the person giving the prompt doesn't really have that same level of control.
Right. The AI is kind of doing its own thing.
Exactly. So
Yeah.
that's a big part of why they think human authorship is still necessary for copyright.
Okay. So that's about copywriting the stuff that AI makes.
Right.
But what about the stuff that AI is trained on?
Exactly.
Mm.
So now we're moving into that second area, the lawsuits that are happening
Yeah.
against the companies that make these AI models.
Right.
Like you got Stability, AI, OpenAI. These are the companies behind things like Stable Diffusion, which creates images,
Yeah, I've seen that.
and ChatGPT, which can write text.
Yeah, ChatGPT. I've heard of that one.
Yeah. And there are a bunch of lawsuits that have been filed by visual artists,
Yeah.
like Sarah Silverman
Uh-huh.
and authors like Ta-Nehisi Coates.
Oh, wow.
And they're basically arguing that to make these AI models so powerful,
Yeah.
the developers had to feed them huge amounts of data.
Right. Tons and tons of images and text.
Exactly.
Yeah.
And a lot of that material was copyrighted.
Mm-hmm.
So the artists and authors are saying that by copying their work without their permission,
Yeah, to teach the AI.
to teach the AI exactly that the
Yeah.
companies broke the law.
Okay.
They're saying, look, we have the exclusive right to make copies of our work,
Right.
and you can't just take our stuff to train your AI without asking.
So they're saying that training an AI involves making illegal copies of their work.
Exactly. That's their main argument.
Okay, so what are the AI companies saying to that?
Well, the AI developers have a couple of responses.
Right.
One is that they're saying, hey, what happens inside the AI during training?
Yeah,
It's not just like a simple copy and paste.
right.
It's way more complicated than that.
So they're saying it's more about analyzing patterns and relationships in the data?
Exactly. They're saying the AI is learning from the data,
Learning, okay.
but not just storing it, as exact copies.
Okay, so it's kind of like a black box.
It is kind of like a black box. And to be fair,
Mm,
because these little cases are ongoing,
right.
there are confidentiality orders
Okay.
that prevent the companies from revealing, all the details.
Right, so we don't know exactly what's going on in there.
Exactly. So it's kind of a secret recipe,
Yeah.
The AI developers are also saying that some of the other legal claims that the artists and authors are making, things like copyright management information or unjust enrichment,
Okay.
they're saying those are preempted by the U.S. Copyright Act.
What does preempted mean?
Well, it basically means that because copyright is a federal law,
Right.
it kind of overrides any similar claims that are made under state laws.
Oh, okay, so federal law trumps state law in this case.
Exactly. And that's a really important point,
Yeah.
So at the end of the day, the big question that all these courts are trying to figure out
Mhm.
is whether taking copyrighted material and using it to train an AI model,
Yeah.
whether that counts as direct copyright infringement.
Okay. And I guess that's what the judges are going to have to decide.
Exactly.
So what's next for these cases?
Well, the next step will probably be what are called motions for summary judgment.
Okay, what does that mean?
So basically, each side presents their arguments and their evidence to the judge.
Okay.
And they ask the judge to make a decision without even going to a full trial
Oh, wow.
because they think the facts are just so clear.
So they're trying to avoid a trial.
Exactly. And our source suggests that this could take another year to a year and a half.
Wow. So it's going to be a while.
Yeah, these things take time.
So it'll be a while before we know the answer to that question.
Yeah, it's interesting to note that a lot of these lawsuits are happening in just a few places,
Oh, really? Like where?
like Northern California, Manhattan, and Delaware.
Interesting. Is there a reason for that?
Well, our source points out that different courts, different judges, even the people who work for the judges,
Mm-hmm.
they might have different levels of understanding about technology and art.
Right. So like a court in Silicon Valley might be more familiar with how tech companies work.
Exactly. And that doesn't mean they're biased or anything,
Right.
but their background could influence how they look at these cases.
Yeah, I can see that.
So it's possible that different courts might reach different conclusions.
Right. So we could have different answers depending on where the case is filed.
Yeah, and that could actually create even more confusion,
Yeah, for sure.
And it might even eventually lead to the Supreme Court having to step in
Wow.
to give a nationwide answer.
Yeah, to sort it all out.
Exactly. But in the meantime, we might actually get some hints from other cases.
Oh, okay. Like what kind of cases?
Well, there's this interesting one called Doe v. GitHub.
Doe v. GitHub. Okay.
So in this case, a bunch of computer programmers are suing GitHub
Okay.
because they say GitHub used their code to train an AI model that can also write code.
Interesting.
And this case is actually scheduled to go to trial.
Oh, wow. So we'll actually get to see what a jury thinks about this.
Exactly. And that could give us some real insights into whether creating these training data sets involves unauthorized copying.
Right, because the computer code is protected by copyright, too.
It is. So the legal principles could be similar to art and writing.
So even though it's about code, it could tell us something about how the courts view this whole issue of AI training.
Exactly. And there's another case, Thomson Reuters v. ROSS Intelligence.
Okay.
This one's in a court in Washington, D.C., and it involves using copyrighted legal summaries
Mm-hmm.
to train an AI model that helps lawyers with legal research.
Interesting.
And a decision in this case could help clarify whether just gathering copyrighted material
Yeah.
to make a database for AI training, whether that counts as copying under the law.
Okay, even if the legal documents themselves can't be copyrighted.
Exactly. So even though these cases aren't directly about, paintings or novels,
Right.
the core legal questions about AI training are really similar.
Mm-hmm.
And how these cases turn out could give us some clues about the bigger lawsuits.
Right, against the AI developers.
Yeah. And, as the Copyright Office itself has admitted, there's just a fundamental disagreement right now
Mm-hmm.
about whether using copyrighted works to train AI
Yeah,
is actually breaking the law.
it's a big debate.
It is a big debate, and it comes down to how the courts interpret those specific rights that copyright law gives to creators.
Right.
So those rights include things like the right to make copies,
Mm-hmm.
the right to distribute those copies.
Right, to share their work.
Exactly the right to display their work publicly, the right to perform it,
Mm-hmm.
and the right to create new works based on the original.
Right, like adaptations and translations and things like that.
Exactly. But here's the crucial part. Copyright law doesn't give creators the right to stop any use of their work.
Oh, that's interesting.
Yeah, and that's a big difference from patent law.
So with patents, you have the right to prevent others from using your invention.
Exactly. In pretty much any way.
Wow. What, copyright is more limited?
It is. It's more about specific actions, like copying and distributing.
Right.
Not every single way someone might use your work.
Okay, and I guess that's why this AI training debate is so tricky.
It is, because it's not always clear whether that training process falls under those specific rights.
Right, that copyright protects.
Okay, so we've talked about the lawsuits. We've talked about the arguments.
Yeah.
Now let's shift gears and talk about what the government's doing about all this.
Okay.
So we know the U.S. Copyright Office has been studying this whole AI and copyright issue, right?
Yeah. They put out a report, didn't they?
They did. They released the first part of their study back in July.
Okay.
And one of the things they said is that they support new federal laws
Okay.
to protect performers.
They're performers.
Yeah, like actors and singers and musicians,
Right.
to protect them from having their, voices and likenesses
Mm-hmm.
used without their permission.
Oh, right, like in deep fakes and things like that.
Exactly. Because AI can now create these incredibly realistic fake voices and appearances.
It's scary how realistic it is these days.
It is scary. And so, it makes sense that they're thinking about performers' rights.
Absolutely.
Now, on the other hand, the Copyright Office has said they don't support new federal laws
Okay.
to protect an artist's style separately from the specific artwork that they create.
Oh, so you mean like you can copyright a painting, but you can't copyright the style?
Exactly. So
Interesting.
they're basically saying copyright should protect the unique expression of an idea in a particular work,
Right.
but not the overall style that an artist might use.
Okay, and why is that?
Well, they're worried that protecting styles could actually stifle creativity, make it harder for artists to learn from each other and to build on, existing artistic traditions.
Right. I mean, artists are always influenced by other artists, right? So
Yeah.
it would be hard to draw a line there.
Yeah, it would be really difficult.
Okay, so what about that case involving Midjourney?
Ah,
I
yes.
heard something about that.
So this is where it gets even more interesting,
Okay.
because this case is not just about copyright.
Okay.
It also brings up trademark law and unfair competition.
Oh, interesting.
So it's a different angle
Yeah.
to address these concerns about artistic style.
Okay, so what happened with Midjourney?
So apparently at one point, Midjourney was allowing its users to ask the AI to create images in the style of specific artists.
Oh, wow. So you could say, I want a picture of a cat in the style of Van Gogh.
Exactly.
Wow, that's interesting.
Yeah. So you can see where this is going. The artists are basically saying that by doing that, Midjourney was creating this false impression that those artists were somehow involved
Right.
or that they endorsed the platform.
Right. Like they were giving it their stamp of approval.
Exactly, even though they had nothing to do with it.
Wow. So that's where the trademark and unfair competition claims come in.
Exactly.
Okay.
The artists are saying that this could hurt their reputation
Right.
and their business,
Yeah. Right. Because people might think they're working with this AI company when they're not.
Exactly.
Yeah.
So it's a clever way to kind of get around the difficulty of copywriting a style itself.
Right. They're using a different legal tool to protect their names and their reputations.
Exactly. And it shows how all these different areas of intellectual property law are starting to intersect
Yeah.
as AI becomes more and more prevalent.
It's a whole new legal landscape.
It is. So finally, let's move on to that third area we wanted to talk about.
Okay.
Collective bargaining agreements.
Right. The union.
Exactly. So we know that a lot of artists and authors, especially in the entertainment industry,
Yeah.
they don't own the copyright to their work,
Right. It usually belongs to the company that hired them.
Exactly.
Yeah.
So how are these unions, the groups that represent all these creators, how are they trying to deal with all this?
That's a really good question.
It is a really good question. And this is where we're seeing some really interesting developments.
Okay. Like what?
So labor unions are actually starting to negotiate specific rules about AI
Oh, wow.
in their contracts with employers.
So they're trying to get ahead of this.
Exactly. And one of the big success stories here is the Writers Guild of America, or the WGA.
Right. The writers.
Exactly. They represent screenwriters and other writers in the film and TV industry.
Yeah.
And, they went on strike last year.
Yeah. That was a big deal.
It was a huge deal. And AI was one of the main issues they were fighting for.
Wow. So what did they end up getting in their new agreement?
So they got some pretty strong protections. First of all, the companies cannot require writers to use AI
Okay.
in the writer's room.
So they can't force them to use AI.
Exactly. That's a big win for the writers.
Yeah.
Secondly, if a writer does want to use AI,
Okay.
they have to get permission from the company.
Okay.
And the company can actually say no.
Oh, wow.
So the writers have a lot of control over how AI is used in their work.
So it's not just the companies calling all the shots.
Exactly. And then there's another really important provision.
Okay.
If the company gives a writer some material
Yeah.
that was created by AI,
Okay.
they have to tell the writer that it was AI generated.
Okay. So no sneaking it in.
Exactly. The writer needs to know what they're working with.
Yeah.
And perhaps most importantly, that AI generated material doesn't count
Okay.
towards the writer's pay.
Oh, that's clever.
It is it basically disincentivizes companies
Yeah.
from just, using AI to churn out scripts
Right.
and then paying writers less to just kind of polish them up.
Yeah. Yeah. So it protects the writers' jobs.
Exactly. It's a way to protect jobs and to make sure that writers are fairly compensated
That's really good.
for their creative contributions.
Yeah.
So now how does that compare to what other unions are doing?
Right.
For example, the International Alliance of Theatrical Stage Employees, or IAT.
IAT. Yeah, I've heard of them.
So they represent a lot of the behind-the-scenes workers in the entertainment industry.
Right, like camera operators, set
You know,
designers.
exactly. Costume designers,
Yeah.
all those folks.
Yeah.
So their agreement with the AMPTP, it does have some rules about AI,
Okay.
but they're not quite as strong as the WGA's.
Oh, really?
Yeah,
No.
so for instance, in some roles like scenic design,
Yeah.
the producers can actually require employees to use AI.
Oh, wow. So they don't have as much control.
No, they don't. And
Yeah.
so those protections against, potentially losing your job to AI,
Right.
they're just not as strong as what the writers were able to get.
Okay, so it sounds like different unions have different priorities
They do.
and different levels of power when it comes to negotiating with the studios.
They do. And it shows, how the WGA was really able to leverage their power
Yeah,
to get those strong safeguards for their members.
that's interesting.
And it's worth noting that the Animation Guild,
Uh-huh.
which is a local branch of IATC,
Right.
they're actually negotiating their new contract right now.
Oh, okay.
And given how successful the WGA was,
Yeah.
There's a good chance that they're going to be asking for similar guarantees.
Right, for the animators.
Exactly.
Mhm.
Because, animators are obviously also concerned about how AI could impact their work.
Yeah, for sure.
So, it's really clear that these unions are playing a crucial role
Mm-hmm.
in trying to figure out this whole AI situation
Yeah.
and to protect the people they represent.
Yeah, they're really at the forefront of this.
They are. So to wrap it all up,
Okay.
the legal world around AI and copyright,
Yeah.
it's just incredibly complex.
It is.
And it's changing all the time.
All the time.
We've got major lawsuits trying to figure out who owns AI creations,
Right. Mhm.
whether you can even use copyrighted work to train AI.
Mm-hmm.
The government is studying all this. They're thinking about new laws.
Yeah.
And the unions are right there in the mix.
Yeah, trying to protect their members.
Exactly. And, for all the creators out there listening,
Yeah,
it's really important to stay informed about all of this
absolutely.
because the rules are still being written.
Yeah, this is a really dynamic area.
It is. So this brings us to our final thought for you today.
Okay.
As AI becomes, even more integrated into how we create things,
Mm-hmm.
how are we going to define what it even means to be an author anymore?
Yeah, that's a good question.
How are we going to balance
Yeah.
the amazing potential of this technology
Right.
with the rights and the livelihoods of human artists and writers?
Right, because we don't want to leave them behind.
We don't. And what responsibility do creators themselves have
Mm.
to understand, these really complicated legal and ethical issues?
Yeah, we all need to be thinking about this.
We do. It's something we all need to be thinking about.
Yeah.
So thanks for joining us for this deep dive into the world of AI and copyright.
It's been fascinating.
It has been
A lot to consider.
a lot to consider, and we'll keep you updated as things develop.
That sounds good.
Until next time.